Same way na America. Same way na America. Ni entie ni yie. Ye won krofo bi wo Ghana ha, ya bubọ wo mu din se wo mu soso no etu galamsey ni bi. Ya mean tie mi papa. Abanga a we third vice national chairman of NDC. Uso tie mi bi. Se wo ba Ashanti region so a ukọ Adujama DC any MPO nana hima apamu na free na himfie se wo tu galamsey. Se uko Aowin constituency MP no won ye fe no Oscar Labi nana no matwa dwan ya gu ne so se wodan wirem onkofie en wo tu galamsey. Oti ase mo ya bubọ mudi nyina no mo hwe ade a atu Wontumi 20 years mo de how many years na mo betimi enya enti enne no ema wani nje because NPP ni a oye chema Wontumi ene ye de na tumu na me de tu e de na tumu no wo tan eni bre oti ase ensem fata oti ase aho ya da bia NDC ehu wo mo no omo bade omo ba no se ehiafo ne asikafo be pe ebe wi ase no na omo anya omo hu se tam da bia sa na de ye na me de me se nyame na nipa nyina destiny ana se ne bibia no ehye ne nsem nipa hyebre enhye nipa nsem nipa hyebre ehye onyame nsem eti me stress ye nyina no ye nhwe dia akosue se dia akosue ne be magalamsey eja idea ene ye nyina mbo na ye mbo abaso na se enne wate se saade we ya to Wontumi na emma galamsey enya idea ene eminua ye ndwene hu ne ndwene hu mienu
kumasi yami NDC national organizer wo to ofun galamsey se de ode ne nsam mienu didi kumasi Ashanti region na making yami
waso enu mo se capitals ni nyina ni yentu galamsey to villages
and I'm saying Ashanti region not Kumasi to be precise. Ashanti region kese me no mienu nim baby a mining ni galamsey ekoso baby on mo villages ni bi on mo yentini embody e bia ye hu ni din sese because of the emirati but that doesn't mean say galamsey enkoso Ashanti region galamsey ekoso gidi NDC for ya mean to be precise o de ekwa ehwehwe mu also buy a man appointment to one day do be no wo tu galamsey me say wo tu galamsey gidi
ya me so buy a man appointment
me say oba no ye man appointment bia galamsey e no aye campaign e wo Kumasi no wo tu galamsey gidi mbetu tu galamsey ase mun ko fo de gubu so mutu galamsey e dey ase na na do dan ko kufu ado tenkan ha e so mo se ono ye ato ni party for gurem e no wo tu galamsey and on this can be no Jubilee House. Saturday this is 14 akomo mu kai. Obi se na na dan ko akufo ado. Oluma na oti Jubilee House obu amamu pamanko enkwala ko school free no. Ono na ode ne wo fa asene ne party for egu bush e no mutu galamsey. Eti omuto Jubilee House ko edini. Se galamsey no a yetu o Ghana hanom no. Efi Jubilee House. Eti yentimi ntu asieda. Eti ene de ene koso. Enti ene owura John Dramani Mahama president opesa yan kan chele say galamsey na ekoso na yensuo se na ye niane ye bibia na obeka se obia wo ati ne company na otimi to gold ni bi parce say no NDC abana me yehun say obia ni Ghana ha obetimi ato gold every ni minor ana galamsey ye bia ansem apart from Sami Demfi yes obia ni Ghana ha no ma obetimi ato gold every gold dealer bia apart from Sami Demfi. It's Sami Demfi gold now all turn on SSF when you gold bebe amagana am faso aba no. Ahim for all to gold nifi. Auto gold nifi is small scale mining for her. Auto gold nifi Anglo gold for her. Auto gold nifi Newmont. Auto gold nifi Hefa. I saw ba no better baby auto gold no bebe na so wanya no. Auto free.
And you say Sami Demfi galamsey for no to gold wo mo.
Meba Sami Demfi auto gold nifi for Ghana. Mibusa say Sami Demfi Sami Demfi as a gold boss CEO. Gold na auto free for me Mibusa I can say for you to gold free more. Now I can say for ya.
O sir.
O busa me say I can say for ya no to gold free more.
Mo no mo police mo na ya mo ko ji.
To free more. Minus me can say for ya no to gold free more.
Minus me.
Na for the sense
Some okay,
small
scale
small scale mine is nigga. I'm saying for you now, more not to go different. Because first now not gold board. And the directive said, I was a gold board on quality to gold. Oh, Ghana Hanam. Now your institutions in the companies via or more lines are almost to gold. If you uncrown crown, who come in the crew in number one say, and comforting the J office or Honor, now move to gold. What I say, I will cut and cut, I move back, no more better trauma, or with a better Kumasan and Carabaton trauma, or more to gold, I can say, and I open on my Mahama say, Obi any or South companies now, so be any guys who to gold. Why they say it's cocoa, yes, they say no. Said the Obi to cocoa apart from a bino. It's a say no, some of them think one a gun animal, or Timito gold, or turn the boy on our pet, a free galam say for no. A boy, some of them feel to gold, Ghana for him. So be in the country. A boy, some of them feel a to gold, a free minus, and I said galam says for no. Ye on one I call no Oba akunta buo bi ani ye friend parliament class o mechechim kra ye say manema up to now me no mienu eno aso ono achoa no police kan kakra ba ai mato gold me nya say enti me say na the gold reserve ye say and I say hwete ni eko akunta buo papa bi ani wa ekoso e wo mampani Mahama amamwe mu because omo ye untouchable until so ombe free aban no. So obi sebi adi sakura open them Mahama company a obeka say wo nya hwe no oto ne san e wo no but wan say that but NPP ni die wan say that police say Natal ekwa kotwi NDC ni bia obedem enra asem wo nya asem say enna me ko Diamond TV yeti TV ni so ye ntokwa gidi ma TV show de kwa ye nwie akokura bi so ye NDC ni na ye ba kusha ni ye kasa minim ni di kura mi pe ni di so papa bia o di chinewu also NDC communicator yet show so ye show no kasa ye
ai abrante kesi abaya ya kochina ya invite na doji ni e be chewa yes NPP for sorry aputo abrante be Wontumi message ni case squad de me akwa be kika bia kan kwabra na nyino na leader ma NDC it be for 37% or Ashanti region what $1 million per constituency project yes yan fanko police station constituency officers on community side one you na branch ege wanye who ye obetan say yanko to abama what you hu sika Wontumi wanye one na kura andi na muka say yanko siafo so me NPP ni ti mi mpia bontena mi kodi Wontumi ege na obi a wodi sika wa ben wan fa kon papa bia na ndisi fo antimi anche wo mo a na je sabi o dokuna o mo yanko siafo empeni fo na bi obi ti ho obi ti party mu pe jan komo 1000 akotonsuo na maswexka empani for na defa na we ne yakochewa is party for sorry party ni be necessary sorry me ko instrument ko je besia akoya adwuma oba na me ko ka se be regional first na former chairman there is party ni be gina bechi na me ka chiro se be party chairman enu kwansem be before se be ayi ni be so ko ye party abo so ka tampo ayi campaign na no ko pa ya che na dia and the party for be
utie nsema ono akan utie nsema onto so ono oni minister da oni ayi
minister da we businessman
and he was defending the
we businessman akoje SM bank no so the kodu aburo one ya office ka no na ban bia ba na be ya konta we wacho intimidation be no mo ye o uta ese so trio o man sika de ma no uta NDC ba power and o me announcement I hope say o mo first chief of staff say from January to February me and your payment na kuma no fi say wanya ye chiwo ye se bla be yi anu a we enje NPP for so le medu ochi na NPP a we chairman and so we organizer we go dey che na nu dey over so ye NPP say dey tete ye which has basso kuzika na me kai say ma party for MPP be share 500 200 akwaji ni nyina ade abom afa which na nsam no kwa dey afa ni ye be kika na kase minya
and it's a unity ya okay the ema
so what is your unity asem akwaji money ni e cho efa party unity be akwaji money na NDC for tatawa efa party unity be etike me enka no man inside yeah you want to be say ka this is one day on my power be almost obi agere ni ema he media me support ade aye bone da and the MPP me nya hwiwo because me kan kura dodo me twatro da abrante no yemfa no nko na wa obi ko ko die chese me ko defend Wontumi de na me nja oni side back kro so ye kronfo Omunyano, no uncle. So be been to me. With a reaction. At yes, oh yes, a poor penny dear or the penny. Which has paid the name of Ashanti party office. I never know because NPP can you come here. A check of hotel. A check of enemy. Go water region. Go your party office, the water region. Or what yes you. If you got this $50 million, say CDC. And you want to mean you will be. Somebody put to structure the apartment. What are you cabin some? What is it? One in Akura and Dino. Yesika. And go for you no $8 to the give. The papa. Ghana for better up. Ghana Namiko on shroud. Nami on shroud. And crying for brother. They champagne for a part of it. Maybe say, or back to me some quasia. Ah, now me push out and I'm usually you know, say, be a quasia. Quasia penny will be a tomo bushy camano. Some from local Bob Jacotan Kayatia. A dear marsh and a fan quasia. Now maybe the true shine about Kuma, as we back getting a coupon. And I'm sure my cacana. And the J. Which is not politics and credit theatre. The Sika and go for you, you cheer Sika at the farm. Dollars. Now, yes, a party for me. No, I don't go on the money in the uncle. Don't be ever back, Mr. Coco, a table bombata. Coco will get him up and you one day. A prayer, a school year, if you could be all your friends. If you could be Uko, a Minnesota, assure you a coin you to me at the man one. Now, what you want who could defend them? Then you can't be the Dilusu lesson. And can't be. Come and cancel the Kama $1 million per constituency. Schools didn't like them. Why you whisker? I Uka, that is a unity. No, may you mean you know now you are getting an empty as a casualty and your unity.
Mr. Copim said, the okay cane in Ano. Yes, Obia a suspect until say be proven guilty. And Sunny, go become Rose, you cry okay. Maybe as a guy, the man, no show of maybe a next kind of ground good. I think what a man throw be a so do it. Call never documents. Near water and this so never. And now I feel so many coins or more car, but I ain't here or more with the cause or more. Almost friend, inviting one. Oh, material lawyer and the appeal. Oh, because of mine is 17 and my friend. And yet, I say, be no Babaka against him. Madame for lawyer Piacobi, may you obey. And a lawyer, no, and your party to Ukodinaki. And a lawyer, personal lawyer. It will be defending. Never was our lawyer, dear, and fair party, Libya. Call Obi Piala Wafum Ghana. Mamma, what the woman should MPP, the other Uncle no go nothing. Say not president or and say one uncle the president make it a more matter.
And say some coffee, so I can see a discuss it. The chairman Wontumi a feminine. I mean to me kind of usual. I don't mean to mean flow. Say there was a me flow because yeah. They are touching my wound to me. A bit me to me. A bit me at all. A bit me at all. Be in Shankan, I may say a shall see it no. TikTokers no. Any NPP executives Binua, the almost shall see no party no antiana. Party no antiana. Lady can you have a kawaha? Bono ni noa. The uncle of goodness a child Ghana Baba Mando. Yeah, Mando. See, shall say no one I can be known for say, and ne be seen in charge of the ball, Baba Mando. But the hunk of goodness, I admit child Ghana winner. Is she high? Sabia Branty no canning some of fair moon. A true baby cross over me. A Branty no on your criminal. Breaky jail. So obeying who ya, hunk of Nanisa, Master Union we. Look at this. And he said, what's your mind? Near the say, dimuni pebi. Now what's your now say and family home? And me bore me punum. A salmon be mamma chin, to miss me money dear near. A bear cacrano, a bepa was also. Obia. Share TikTok see. Ghana, is it the first time? Ye nyanko of what's in a phone and nim. asopa nipa bi. I will not in any way endorse obi obedidi panyini atem. There be obebunu ensew so obedidi panyini atem. Nemo megidi se wo mu a na mmara no hye wo nsa. Emire bi atwa mu no. Safo no an mmara no mda so omna mmara no hye na Ghana police yaje omutumi from some dia many powerful bia. Ghana ye court see ni omutumi fa ma ni pa mu
Debbie.
Aye wo mu an wo mu hye ye mmara ne so. Anda nanado danko akufo ado ni Alhaji Dr. Amudu Bawumia no. Aye wo mu an da so tewa wo mu hye ye mmara ne so. What has changed? Nipa bi kura timi koi the extent say akufo do wu aeroplane kura na nipa bi anwuye. Some judge described Nanado Danko Akufo Addo say oh you useless wan kasa konwa no wote so no. O say oh you useless president ever. Na che say o man panyin ne yedi ne hwia anye ye bibia ho mfaso che o man panyin eno mpo o man panyin Mahama ahwe amma some judge appointment or your minister because these in komo na ye bia o mususu se e pam NPP for free akonwa no mote so nsemu abayo ano keka ye no emfra no asotwe no ne se so okodemu ana nti kokobo ni ho se ka kokobo ho okay so ade no e BSC that is not as if this is the first time obi kaseti apanyini. This is not the first time NPP ni bi anywhere o endorse atimdidie at the time one no opposition and some kaye sabre na nyese NDC ba ye na TikTok e sabawu no mo system nim atimdidie and some enfra ba said yes opanyin bi matemante no adidimu enne hwe NPP mpedifo ekwan ya de omo faso onim se Wontumi case chairman case the first case almost o madi awie akire se obia watena fidie so pen adidi chairman Wontumi atem so oye galamsey no chairman betimi afasa video no de siw ni bakro onim so mo ya saade ni nyina na chairman betimi afa those videos e de siw ni bakro because bibia ni wa and the biansu ni wa pm oti adwam ekoka se chairman Wontumi eye galamsey enti say ye illegal mining ho nsem ntina chairman Wontumi ye twe na so se onko da fiase efia duro no ne dia enne the big question is illegal mining no ejaya na enne kura na atisi enne no wo ye na kese even o man panyini Mahama no anum to se na point is ni bi ahemfo ni bi eye galamsey ese se ni friend ni so be to boaboa na ne nice bi so until at the time o man panyini Mahama ka se na point is ni bi at the time when NDC focus o mo point is ni bi eye galamsey no e kire se o mo nim wo mo ye galamsey what has happened to those people dia na to mo nothing bibi anyhow nansi asemu a kukuruye NDC national organizer ho sa akoda amudo mo ye nipa NPP fo nyina amu ye nipa NPP fo nyina okay so nanka be ye de be ye nwanwa se judge betimi akase ye ni evidence akonta mining eye illegal mining nemum na saase ena obi e de ye sa mining no nipa krono de won fa ne honi and there are pictures that show say region sa concession or Samana boy right region a western north or western region yeah. regional woman no the then minister say our pictures okay deputy minister ekodi adanse e court say wo kai say akonta mining trouble ministry ho say enkofo bi abanasa ase so e de yade a enfrenti yemma no nkofo no fa mo asase no asojafo ani police fo fa mo asase no ho ban so na adanse ben e na chance adanse wey a deputy minister no ankasa o member of parliament abakot wabeto na num to say they have pictures and they have the letter Kunta mining company Troba the then Western regional minister say yam nkofo no monko boban san say nkofo bi say na sase ensani pano nenne wakodi adanse ama abanya de no wo say asase no na akodi adanse ama abanya enne chema Wontumi yesi ya man 20 years no he said biti ho abofra biti ho na walking kind no ka se da bi we de chema Wontumi Ashanti regional chairman entia wo ye NPP ni nti ne ye ne saa nipa no wodi ka o ye NPP ni nti ne ye ne saa enti NPP for dia ashase no yesi why no see yedem yonko ye neme yesi okwase na see yedem yonko ye neme o chena betimi abawo so sense ko wana na sense kura na sense twanto so de obi abetimi atwa asema ato so wo twa to so na kokot na wo a judge beka so de dipa na wo twa ntrato so no de wo kana ye no kre obetimi ageliu. But I like the position of the party as we speak. My main comment the Alhaji Dr. Amudu Bawumia. What chess or your penny? What chess or your penny pa? Yes. What chess or your penny pa wo chefie? Na the idea enye di ne ba won tena se. E me emfasa ade no a enye no ni ne ba. Shana monwa wotu. The extent that Papa no kono. No wonder say NPP delegates cause sound like Otuaba or Mutoma Alhaji Dr. Amudu Bawumia. Because NPP delegates omo nye mistake da. Omo no mu wa chiri. So man penye ko focus e brebia ne kandini ye hia no. Indeed, this is the right time. Aye, hia Alhaji Dr. Amudu Bawumia na badaye. Na yem ye ne tema woman nipa. So we say in crime. Just wo someone man NPP wo mpanyin for me mpanyin for papa etawachi. Let me commend the general secretary of our party. From day one. Ono so chen ho mfiasem we mu. We commend the general secretary and all the leaders of our party. Over the national executives Nanabi and others aka no more abaso esa say omunyi chema Wontumi mind since day one and we say ye mu bin crying say wo ya ade na ya ade pa koso ye na de bebe bia no party no beta wochi eye boni ben nanti obi woni fie nipa no edi ni fia ma han wo de emfa nse obi kura ne wo ni fia no tenant bi na se tenant no akọ fie akora bi wo fie ho na ye de fie wura ya be che fie wura akotum na tenant no a wo kọ fie akora no ne nam ho aba for Christ's sake say eno na asi o we na asi yesi fie no na wo dia na senya tenant kra na o legitimate tenant kra no a wo mu adodo mprepemfo bi a mo mebo fie wura amane ya o mo ko dodo fie mu etena mu wa bra bi a fie wura anya we no saafuo ni bia betena wo fie ho na obetena wo fie ho no wakodi nsamoni wo fie ho nipa no nie nya se ehu no yes minim se Ghana mra se koba se bibi esi wo fie na de oye ye ne yehu no de a wa japade ne ye wo dia no but here is the case dear wo yes abone numom ne kodi adanse e de tie ne fie wura na Ghana mra achi ne fie wura ne de na 20 years nti wei eyo my ben asade we bisim senye bia obi na abone timu pose wontumi de kiane kiye de obetum NPP for de kiane kiye de mo betum a wei ye didi hwan sa mra wei e hwan ne didi no. So you see omo wa ban mu a bia omo ani age sa bre no said ye nantwie ni dua anka ne to no there is no way say be ka conference there is no way enka conference na sa bre ni du hwa ani be hu ba bia ye nyina ye de esusu ade body ho no e be fa sa bre ni du hwa ye nyina be hu ba bia esusu a ade body ho no be fa. What kind of life is this? Hunani intimidations no. Where enfe dua ne meto table so. E komo de Ghana for ma. Sabe asem ya ye de afore for Wontumi e de na kotumi. Ama obi aduane adi. Woman su ya ye ti kwalachi ya ba ya nimu ana.
Galamse no kwa fe no mutu no mo.
Mutu na kese.
Ono nso nye galamse enso ya jele.
You get the point. So Ghana for mamu nyai wo kun we ma NPP for nko asa yenko. Mamu nyai wo kun we ma NPP for nko asa yenko. Esa se friend people for so
some can say tribunals no mo ebie no.
Journalists. Some friend people for so and ye no de omo ntimi nkan ya no ntum. Enti say ya no mo beye so mo antimi ankan ya no antum no mo jump from yen so eya mo so no mo de ba o journalist am krom ha bibi nti bia mo ntimi nkasa mo fo say NPP ni na fa no ntimi nkasa
so man shall say bloggers use
yes
TikTokers
that is it
tinka krakra
enti mo from so mo de ba mo so amu from so mo de ba mo so na mo ankasa mo kenkan verdict no a ba ye no net mo sen okay kan ya net mo sen omo ankasa gitum say chema Wontumi ene akonta mining company omo fa kwan paso no omo gi omo concession so omo de ye adwuma e kwan o fa so wo je ne concession de boni bia ni ho na mo obi ne so wa fa kire no akoye ade a emfa nipa no nenam ho na de ya ne say sa nipa kro no ankasa ene kodi adanse e di ti a chema Wontumi ene yesi ama na 20 years no ye mo so wa say asase no ono na kodi adanse eti a chema Wontumi
nante
so baby a ekono Ghana for mama ye ntenase ye the NPP for the ye ta chema Wontumi achi the ekoso bia no we are with him, we are always with him. Na so free NPP omo free NPP force no mo sha ase so mo de ba mo so ena ye nyina ye be hu baby a oman no sese eko eya niema bi na ya omo hihye eya niema bi no omo hihye ensa niema no omo hihye no ye de ye hu akire ensa mu ameka ye ho no omo tiri succeed in doing what they are doing no mo free ye so a omo de ba mo so omo de ba mo so asem we why ne dey asem we bi edin wo Ghana ha se nya chema Wontumi enya NPP for NDC for betata ye no dey asem we bi die ya why pa ne dey asem we bi edin wo Ghana ha why
no me can say bi wo hadum say be justice reps TV3 interview I no can say omo no dey oh now just obuni evidence bia na emum no chema Wontumi enum asem ena obugina so na ana judge no gina so no the jail no na just say you ask yourself and I say was that touching later in the evening it is also question say who be judge na just who need evidence of your own now watching kofo akoshe dem heriokunum sebo sizi omo passport o sebo yo de normal say yes odi de yes say ye be so ye mo na mo say so ye legal miners so in fact they are our mining illegally e wo bia sase so mo hunu be dia dance tia chairman Wontumi mo ni evidence bi e enti ono na sem e na mo gina so na mo ko no prosecutor no na dey ni krama na mo de air court
court mo see yi sisi oni asem mo de wo NDC for asem won fa judgment we no judge no utie ese edu nketia ne nkofo asem we isi oso oni asem bi obeka enti de watie no one side no de omo judge mo se mo nti bi da mo se mo nti bi da you get the point so the koso Ghana no anya fe o man panyina kufu ado no a musopa noa kasa ono de wonwene Ghana fo wonwene nipa ho no o man panyina kufu ado be sade we na ban so you will not see this o man panyina kufu ado aban so ni alaji Dr. Amudu ba o mi aban so hu sade we kan bi no hu si e kan nipa no atum no hu ehunahuna ni atata no hu
Harry, mama nkokwasi nkyɛn na mensam review why saa na beba wo kan na wan hwa na ebufu because wo kan verdict no said ye Harry kana na so wudure mu na wo hwa se wo kan a otumu said ye ma bi antwa illegal miners ye jaw omun kwanso wo ba kwa kwachi illegal miner ba no wa jabi because ye open and why o my ben yetimi kwasi mema kwa ba
ngimina chama Wontumi so baby obi anso ma mencha no pa benem say di na chi e kana ho
yes
kana ho pa wo bibia no we besi na benem say Nyankopon be ina free mo bibia no we tese 20 years beto no
oh debi
emmaso because mpanyimfo pa wo mu Ghana ha a wo mu ya lawyer fo mpanyimfo wo mu aye judge fo kura panya pie no ebinom ka chese judgment wo mu ntiase lawyer panyin pa se kwa be mama na kasa
lawyer say frefre otum say omo kan judgment na
oba 85 years the old pa panyin pa wa practice for almost about 40-50 years o say judgment wa kind of 40-page document na on tiasia o mu where judgment na ba na mu made a work catch me
59 ono de ohu say 59 ono ohu say 40 page and I say 59 page
59 page
yeah
but some 40 no it doesn't mean anything
yeah okay
it doesn't mean anything there's a wood sequence now judge
yeah
what's who and I want tiasia so for all the long service I would there the legal practice in on tiasia na say ya nhwe na say Ghana for a lawyer for panyimfo any judge for na nhwe president na wo mu ade to no abekwa koye template they say a wedding card ye yan so di nipa ni di aseso na fe wo de ne ko na ya nhwe ya next time bi no wo beto ka ma obi se wonka ipa ko de ka ko bobia wa wo ye ka wo na no ne be ba be chew nti yan nhwe ne ma ni ye papa betini aka chi obi se me to ka ma for ye take campaign na fa hwe me ba no ma me what I say ye take campaign na hwe me ba no ma me nti usika bia obenya fatua me ba ne fees ma nti say driver no ko kaka no na wo kaka no no de ka ne ko pem ana wo de ka ne ko kunipa wo a wo to ka no ko ma driver no so won fa anya adwuma hwe oba no wo e de be ba be chew nti ye ma ye ni na ho pa ama wo tu judge for no awo mu Ghana ha nyina apu se o se wo mu eti wono aya akokra ya ka ne so obekra ne wako ni mu made a wo ka ne se a judge for wo kruma no mu nka wo ma no ntu wo ho asem bia no bomodin na fa wo ne magu krata so na ye nyina ye hu ne fa ne ma ne ko tutuye ya nya ne sa problem de bebre no e be problem kase pa nti me gidi se de ya me de wo mu kase pa no ne se bebie no ayaka se chema akodi abansika bebie ni ho ayaka se chema na kodwia abansika anaso oni aban wo manso bi na bebie ni ho so ayaka se chema wo ye galamse bebie ni ho en tse wo mu kan nyina chema wo ne concession na concession na chema wo no enu abi na new month for enu abi na takwa wo chema no ni obi o yes small scale man They say money na mo fiti. Chairman ye large scale mining company. We ye the Juma said the sene faso. And I'm running so no or say mrano. O much baby baako pe. We must be the assignment. Or say assignment no nya sa na ye Juma. Say case assignment or can be term say or say money loan wo ba baby a section 46. That will be me check am me. Or say section 46 of the Mining Act no. A chere say nya wo concession no. A wonya bibia no a wo krata nyina ye correct na. A chere say wo betimi awura asase ne so. No akotu agudie no wo ne kwa papa so. Say the senefata emra no ma ho kwan. But omo koye bibi say assignment. And wo ka dem say assignment no there. Emamu was a judgment here we nyina mo say emamu. A chere say assignment no chere say e bia ne ya ye wo hey. Na bia wontimi friend say akonta mines. Na akonta mines say the mining company no. E bi free Australia ba. Was me person me be adwuma no. Na akonta no de nkrata de ama e friend say o de ama sa Australian company no. Na Australian company no ko no otu a. Enu na obetimi a charge wontimi say wa assign na adwuma no ade ama company fofra otu. But we no still na ade ni woni di mu. Ana adwuma di a wo di no so wo di wona asase no so. If I tell you am section 5 no. What is section 46 section 46
provided by section 46.
Into part of betimi 46
mineral operations. Enter the lease area to explore, mine, dig and produce the specified minerals.
Very good.
Yes.
And you know when you listen, who are right to enter that particular area.
Yes.
And you know and you will be there. They said they were talking and work and pepe. It is a kind of idea, and that's what they are called driver. That's a work where the least to cry and say, a cabia, you bet charge you. Say under your watch, no, and not one man will be a coy bibisa. And to be a said the assassin, say, no beer, you bet me a charge you, no be a one's work to ya, and now compensated for the land. Say Nippon and Nipako now, or no so call now, your castle won't go cacana can or the copimoyano. Obiano, or the assassin was a corona coseno. Okaza kona kutukwana wakati wase kona koseno obi di tuesa wonsemwa metese waso di kokunipa ejisa hukuta tuonu na di kokunipa nipa kona oto tuonu ni yakochi no etino osi judgment tese we hu ni ti enwu ne nai enti ono di ade a wokan ne se yenhwe na enye ho bibi amede de meka che ni patriotic party mani nyina se obi anhye den ne yenkoso a ne mo yempaye ye fantastic ma wontimi achi amu a wo musi wo mu ya atamfo na atamfo mo chire mon kosto ana mumu musire nko baabi a mode baye yamani ase no mon fanye na mon fanko be ye kan ne de asisudua sache ma wontimi onye galamse ya onye samai a oye galamse onye bi nipa na wonu no akoko ye no ono na wosenka court no kwa atwena so so we are there ma kwa legally concession ye ne dia ani obi a dia o ye ono ane dia e no mfama any company this was the Italian company be another Chinese company be wo mu ye adwuma ho obi no se kona ko claim ade no mame ye adwuma no ana wo right to obetu said you can section 46 no or right to
because yes worker section 46 yes. I think CC because this week na people say wisdom gumashi experts na or no experts na mining expert okodi dance here the match it will only be our churo also section 40 be on the Facebook page all kind of university also section 46 of Ghana's Mining Act 2006 at 703 reads as attached. Na me kind no near no question per se me kind or say or say as attached subject to this act and regulations made under this act. A mining lease authorizes the holder, the holder's agents, and the employees and the person authorized by the holder in accordance with this act to enter upon the land the subject of the mining lease to conduct mineral operations including that's without limitation to mine for the specified minerals of the mining lease. Now no say answer no oka wo court wo no read the actual way no say Section 46 of Ghana's Mining Act 2006 at 703 reads, and also which means that a mining leaseholder does not necessarily need to assign its minerals rights to anyone before they can work on its behalf, which I reiterated in court. Yet an assignment tag was forced down the throat of Chairman Wontumi. The appellate court said must correct this dangerous precedent.
That is the point.
A political precedent.
That is exactly what the lawyer is saying. But you know, no kabe 87 cry. Oh, yeah. Let me know na kasa sisia. Eti no media misusu say ye nyina ye mo ye ni na ho. Ni ma ye tese say nya dia eye Chairman Wontumi asem ne ye kan ho. Ye kasa about Ghana and ye niam ye tumi ya de maye ahode ya wo tumi num so mo obi ahode se won koso a na so wa mo obi ko hwa e de ma de na che se wo assign bibi di ama no. The assignment only comes in whereby a company bi aba no order the license no masa company no so won fa kwaya adwuma ante sa dia assignment bi ani ba bia e wo sa case we mu eti me gidi se betwe ne ye da mo obi atase dia me de chairman onye galamseya chairman oye large scale business. They said the new month. Any takwa mines in there, they didn't crack any kuta woman. Copy wa. I mean, say, I was saying, me promo de toso. No be a who say, or you be a okuta assassin. Ah, or ye juma assassination. And you know, Chairman show who there. And maybe be a how. Or your political Joseph said, you know, political Joseph. See, a becker wants some, you bet town, you bet you, they all say you'll be a. But at the end of the day, we be free move very big. We be free move big time.
But who said already yet Fubu ya now NDC for say then you tomorrow is program. And they say how selective justice because mine is going on more than ever.
Say what was that about story no?
How but who the crowd can be president. Yeah. About 5 minutes footage also.
You see a job almost over 100 times. Music from Kohone. I think I'm not 3 days today. Almost see a bruise will be 100 times.
As a Chairman would to be
it's a command saying, me the MEO.
Now, my name is Momo Diabokai, Joseph Yamin, I got over there, you know. Oh, silent on it.
Because Ukraine, Shama Yenipa. This is be a winning insider. I had a catcher, who himself was maybe a chamka.
Oh, okay.
Okay, make out baby. I don't know on pet. Every month, be a Prince Bremiska through Nanefia. Say, I know so they are fuck up.
And I can't joke.
Oh, no, beer or your bus and on Pebaswasa. On Pebaswasa, Bakukra. Only a year, Juma, or you straightforward. Or the catcher or catcher on any buffa, or we are, or say from non wedding come. It is a very solid person. The young year. Odonipa when ya di bi obenyansa no bia ono nyamesum na osuaye pastoral duties no kokko suaye onye obi a obenya ne ho asem na boys aba ya nya sky ne nam krom ha ye tuka no ye de nam ha ne ye se wo hu ntimi wo on kan very much reserve na juma no na tembia no ho a oye enti chama ye gya wochi emfa ho ba bi omodo bakwa kodu ebitimi akache so obefrim big time. Na no na be ma unhira no so kwa yakese obi na obetimi abra unhira na seda omo musire no omo besase yesu omo ye omo de no omo bra ba ho ese bia omo susu ana adwomponi bia omo susu ma chema wontimi bia no omo na be ba omo so ana obi bia so wo NDC mu awo tu galamse no bibia no ono so nyakopo obetua ne ka omo akatua ne dia ba mo na nema wo ma yewese no mo nyine se so because the future is pregnant mo mane nyomu nwa the future is indeed pregnant say the new woman make are pregnant na funu kura ba wie what I say o mu tell say I yes a template o I yes a invitation card o mu share say the ade ne ko enti o mu twa template na to invitation card na 20 the ade ya ne say why person invite o no na do dia sesoro na fe bibia wase wo ba so a wo ba beto de wo so to say de call ye wia no sa pepe say de bia no 12 o'clock about 2 times ba ku ye pm na ba ku ye ba wo nyina ye 12 ana anya sa na je enti wo mu bo mu fanto ho o mu bo mu fanto na nya sem nyina na ya na nipa ka ba ye kama Ghana fo nyina ta say Wontumi a political prisoner.
Yes, political prisoner.
Bo mu ye nyina politics. Until say wo mu ni charge bia de bono.
Na judge from day one that just appeal kura be ba ma there bi. Attach here be mu kura be ko Supreme Court there bi. We do what just why you na twinya say o jail no.
Na say you the can say the way omu di case no. After say appeal ko bi. O say the way omu ya no ko obi no ti ase wo dem o. Asama wo mu kan me dia oni pa ko na wono aka no. One man's word against the other. Paper bia no wa e kire say Wontumi the assignment bia ma say kokoye. No proof. Wo so ni pa ko na o ka ya ne de no no watie. Wa bra ona nan kasa de no de wontie. A kire say o wo say nka Wontumi na na kwa asase no sko ya adwuma.
Oath against oath.
Adenta. O Wontumi de meka no say ma won say de. Ye nyina so yen koso aye mompa ye ma no. Na metimi aka de asi so say enna wo ma hyehyɛ anasa poboni a wo ma hye no Awurade makwa ma ne nuru no be sign na no sign so a obepie big kase pa Awurade ehia no dada wo boni fo monye ye ba bia ni wa obetimi chama Wontumi o do wo pa fa ogogo wa yi obepie what as na say sika kokko kra sa na tie so wo ye ho adwuma fejem opieso
better and stronger.
What I say? That's what they for phone na board chairman. O board chairman na dey beba ye Wontumi. If you say nyina atum. What I say? If you say nyina atum, enti wo na say o fi say o bozo o ye bibi na dey tia chairman na betimi aka to say emfa. Na judge for na sorry, a lawyer for sorry, panyifo wo mu nim de. A wo mu nim sense say na wo mu ye no emfa mo ama no. Panyifo nyina asa se kasa. Na me say dey say.
Na wo high court be na me tisa touch here ka bibi enko Supreme Court da bi ona. Just for interpretation. E wo mra ye di edi na. O untie. O de do di ade say. O beka.
For that time. I know me say say the oka say mo bi edi no. Ye de mo bi edi. Mo bi edi no so wonim. E boni bia wa ye mo petwa wo ka. Yo. E bia wo kura wo ye judge no. E na nya wo na abeji wo aketua. Wo ma ne onana no obi be ba asase so I be face this same judgment out here no.
Oh yes.
As I don't know that.
Yeah, you report it so.
Obesu. Wo mama obi di bi be ye oba ana onana no na obesu. Obesu. Chairman,
Bible Exodus what the country say your bear false witness. He who bears false witness against your
smart. Awa yeso no kwa na mepese mbondi enema wa fem okrum ha ya kwa na edidi eche na hu se na wa yere da na obedam na yayi na utie ba ko no so Wontumi bedam 8 years na mse munkoku no
can I should be so say 25 years
go and kill him
25 years no cry
but say so okunu dia na ka shot munkoku no fa ne ko beduam ne kuno okunu wi ase de open answer ka na ho ato but it will never happen.
Samuel Atachia is lead defense counsel for Bernard Entry Boesiako, aka Chairman Wontumi. Okay, so he entered the scene at the very last moment after, date has been announced for judgment, and his previous lawyer, as you say, abandoned him. Then he stepped in to attempt a rescue, however belated. Inus Afseni is former MP Tamale Central and former Minister for Lands and Natural Resources. These are two gentlemen I have a lot of respect for because they are able to say things as they are. Of course, you all know what has happened in the course of the week. That has gotten a lot of people talking. On Monday was Judgment Day in the Republic's case against Akonta Mining Chairman Wontumi, Akonta Mining, and one other who is at large, Kwame Entry. And judgment was given. At the end of the judgment, some monies have to be paid, and Wontumi is in jail for 20 years. if he doesn't make the money payments that he's required to make, I think a total of 600,000 if you look at it. If he doesn't make the payments, he has to do an extra 3 years in jail for defaulting to make those payments. The judgment has come under scrutiny. 35 million lawyers in the country have been talking. Let's begin to unpack it. But first, listen to some of the commentary that went on in the course of the week.
Well, as we have always been going to court as law-abiding citizens, we always go with our lawyers and we always come out of court. And so we're very confident that the two motions that were filed by lawyer Techian would have been upheld by the judge, which was to look into the constitutionality of some interpretations at the Supreme Court and also to stay the execution of the judgment because lawyer Techian was out of the jurisdiction and would be back on Wednesday. And so we were not asking for the judgment not to come on either or not, but we're stating that it be deferred to a later date after Wednesday. And the judge, her ladyship Kokuvite, decided that she was quite all of that and be a constitution herself and interpret the constitution, and which is why we're asking for an appeal.
So you actually were going to court hoping that the decision be deferred to another day, except
absolutely.
But what did you think that decision would be? Why did you think it needed to be deferred? What was your anticipation?
Because of the motions that had been moved. There were two motions that were moved. The first was that the lawyer was seeking an interpretation into the 1992 Constitution and the Supreme Court based on the issues that were on the floor of the court, and also asking for a stay of the judgment, primarily because it was also out of the jurisdiction and would be back on Wednesday. I mean, Thursday is a working court day, Friday is a working court day, next week Monday is a working court day. So any of those days could have been allowed for the judgment to be held, and also because we are aware that the Supreme Court was sitting yesterday on the matter.
What was his last words immediately the sentence was handed over and the prison guards took over? Did you hear him say anything at all?
Absolutely. He spoke with me and asked that we work hard to bring back the party, and we should keep him in prayers, and he's going to be okay.
We therefore call on the Attorney General to publish the state's enforcement record on illegal mining across the political spectrum. We call on the Court of Appeal to scrutinize the denial of counsel, the refusal to refer, and the veil piercing with equal and unflinching record. We call on the judiciary to reaffirm the threshold for constitutional referral, with express regard to the Supreme Court's own decision in the Zanato case. And we call on all Ghanaians of every party to insist that the standard which cleared Mr. Chikese's name in 2016 be demanded with equal conviction today. Let us be clear about what this statement is not. It is not an attack on the judiciary as an institution. It is a call for consistency, for constitutional fidelity, for a justice system that inspires confidence across the political divide and not merely within it. History will not remember this moment for the length of sentence. It will remember whether Ghana, when tested, chose to defend the Constitution for everyone or only for the power of the day. We choose everyone, we choose the Constitution, and we will be judged rightly by whether we meant it. Chairman Wontumi is a political prisoner.
The Patriotic Party has become aware of the judgment delivered today by the High Court, the case involving our Ashanti Regional Chairman, Mr. Bernard Ntwibo-Siakon, popularly known as Chairman Wontumi. Indeed, we consider the decision of the court as amounting to political imprisonment. Indeed, Chairman Wontumi is a political prisoner. It was never disputed that Chairman Wontumi lawfully acquired his mineral concession. It was never disputed that he lawfully acquired his mineral concession. That fact was established and accepted before the court. The central question was whether that concession had been assigned or transferred in violation of the law. It is our respected view that no evidence was adduced before the court establishing any such assignment or transfer of mineral rights by Chairman Wontumi. The prosecution could not produce any evidence to show that Wontumi had assigned his mineral rights. Instead, the conviction rested on assumptions and inferences which, in our view, could not amount to prove beyond reasonable doubt.
Flag bearer of the NPP to assure Mr. Nchiboziako, Chairman Wontumi, that we still believe that the decision by the court was perverse and was erroneous, and it's something that he also informed Chairman Wontumi that he had instructed the party's legal team and the party's senior lawyers to also take over the case. Mind you, anything that we also do is his case, so we have to also seek his consent as well. Even though Dr. Baumia earlier on Friday had met very senior lawyers of the party the moment the judgment was handed down to Chairman Wontumi, the presidential candidate of the NPP convened an emergency meeting of party stalwarts and senior lawyers of the party to also discuss the way forward. He also did come to light that he had to also then seek the consent as well of Chairman Wontumi and also assure him of the party's preparedness to stand by him in these difficult times. Again, the presidential candidate also did inform him that in furtherance to that, he will also be making a trip to the Ashanti region to also meet the top brass of the party, and that of his members of parliament and the council of elders and patrons of the party and party executives across the Ashanti region to also have some closed-door discussions. He appeared very calm. He was in high spirits, but he was also very upset about the judgment as well.
Right, so that's a load of commentary in the course of the week. Straight right from Monday, when Chairman Wontumi was convicted, and that commentary was led in the majority by the NPP. So let me begin on this note. Very brief preliminary comments before we get into the judgment itself and begin to digest it. Mr. Thatcher.
Yes. Dear Brother Samson,
you have said that the judge was in an ambulance mood, but having read the judgment, will you admit that it is sound, though appealable?
Well, I still want to say that the judge, let me first begin by saying this. This is a very sensitive matter touching on the judiciary. So if I commit a short prayer and behave myself on this elevated platform, let the words of my mouth and the meditations of my heart be acceptable unto you, O Lord, who is my rock and my savior. Samson, let me be very honest with you. There seems to be an indecent haste to prosecute what I call political cases. Because there's a justice delivery system in which the judges are not by themselves in a hurry to prosecute people, to adjudicate matters. You could go and do an audit of the adjournment mechanisms in the court. If you do a proper audit, you see that, look, cases are treated in the normal course of events. And a judge could tell you that, look, I'll adjourn this case. Some people can even, some of the judges will even adjourn, 2 months, an adjournment. Okay. So now, this is a special case. They take it to a special court. And the judge will tell you that, look, you can't go to another court and then maybe do a case whilst I'm waiting. You need to come to this court, and then we proceed with the case. What is the meaning of that? It is ministering to the generality of our people. Now let's do an ambulance trial relative to political cases. But when we come to the civil cases about land matters, the same energies these judges are using in trying to, adjudicate criminal cases, are they applied to civil cases? That if you got a very good land case, a judge will tell you, like my previous situation, come to court at 9 o'clock, and then let's adjudicate till lunch time, and then go and have lunch and come back, and I'll close at 4. Are the judges giving, their energies to the political criminal cases, but the rest of the cases which are not so, or other criminal cases, they won't give it the attention? So there is a good grounding for the position that as if the judges are in an ambulance mood to jail people. Let me tell you something which is frightening. Justice hasn't gotten a political term of 4 years. And when some people are saying that let's run an ambulance of a justice delivery system, then we are saying that, we are trying to placate Jubilee House, because they are interested, together with their constituencies, that people should be jailed, so that they will say, this is a very serious government. If you are very corrupt, we're going to deal with you. And guess what? That kind of frenzy in NDC and in Jubilee House should not find expression in the court of competent jurisdiction. A court of competent jurisdiction wouldn't want to care about the fact that, how many people can we jail, so they will say that we are politically consequential. No, that is not justice delivery. And this is my chief concern. So, for instance, when we said we wanted the judge to consider the constitutional matters, Samson, all that you need to do is that, look, I want to make a referral to the Supreme Court, and then the Supreme Court will come out with its decision on the constitutional matters raised by a counsel for the accused persons. And then that should be the way I should go relative to the decision I've given. Guess what? The decision had been put together already. The constitutional matters and even the motion to move them did not minister to the judge at all. And the judge had the judgment written out before, we look at the issue of the motion. What is that ministering to everybody? Now look, I'm ready to, do what I want to do, and I will not be persuaded by any constitutional matter. That leaves much to be desired. So there is a serious grounding for the proposition that judges who have political cases to deal with are in an ambulance mood, and that is not the rule of law.
I ask about the substantive, the outcome.
Well, with the greatest of respect, I wouldn't want to pretend that I'm in the Court of Appeal, but I'll say a few things for your consideration. Samson, it is important to come to terms with the fact that a high court should never graduate into the Supreme Court when there are constitutional interpretation borne out by the trial. I want to stress that. And the very authorities that the judge cited condemns her own conclusion. And let me refer to the Ezanoto case that the judge applied. If you look at page 12 of the decision, the judge cited the Mekankan case, and then also cited the Aduamwa case, and then came to the ex-party James the case, and then there's another case. At page 55 of the Ezanato case, this is what Justice Atuguba JSC said. Indeed, in that case, the court held that a lower court ought not readily to assume that constitutional provision is plain and unambiguous. What is the entailment of this? When you are said that a constitutional matter is before you, and to your mind it is clear that this is not a constitutional interpretation but a statutory interpretation, and where rival meanings have been placed on the constitution vis-a-vis the laws under which they were charged, as expressed in ex parte accusa, the defense is asserting that the law sins against Article 1911 because the law is not clearly defined, the Minerals Act, as to the criminal matter vis-a-vis the penal consequences of those things, and that was sinned against the Constitution. Make a referral to the Supreme Court for the Supreme Court to interpret. The Attorney General says no, that is not the case. It is plain on the face of it. Samson, I beg to submit that rival meanings have been placed on Article 19(1) vis-a-vis the Minerals Act, and therefore a judge should have left the matter to the only forum that is so preserved to interpret the Constitution. And for my part, this is a ground of appeal that the judge usurped the interpretation powers of the Supreme Court, and to that extent became the Supreme Court and interpreted matters that the Supreme Court is supposed to interpret.
You seem to suggest that the High Court judge, once a lawyer or a party triggers what they feel is a question that must go to the Supreme Court, should just fold their arms and push the matter to the Supreme Court. They have no discretion in the matter. That's what you're suggesting.
At all. Far from that. You see, because were there consequential interpretations before the judge, since you give me just a minute, I'll just read some of them.
We'll get into those details.
Yes.
But why do you say that's not what you are seeking? If the judge has a discretion to exercise,
yes,
and she has exercised the discretion, that from where she sits and reading the provisions that you say are vague, for that matter, let's go to the Supreme Court for an interpretation.
Yeah.
And she takes the view that they are plain, they are not vague, she can understand them, she has no need to get the Supreme Court involved. Why do you fault her?
You see, from the jurisdictional perspective, the power to interpret the Constitution when the arrival means is not reserved for the trial judge.
She's not interpreting, she's applying.
She interpreted it and even came to the conclusion that it is clear. And that is a very serious interpretation, because the issues before her were deeper than clear. And even at a point in time, the judge actually said the penal provision is not borne out by the law. I can show you from the decision. She said that.
I read that.
Yes, it's there. So
but she tells you that the punishment, as you are talking about,
yes,
which Article 1911 says, ought also to be prescribed.
Yes.
Whilst you don't find it in, is it 99?
Yes.
99 2B.
Yes.
Within the same law.
Yes.
You find it. So
yes,
she didn't understand what you were talking about, because if you read the law in full, you find it.
It's an interpretation.
It's an application.
Because, you see, she was not applying the law as it ought, because in the sense, when there is a criminal offense tied to a penal situation, a consequence, understand, and one in which it is not borne out by the law that this particular infraction is tied to this, what's it called, penalty, then it sins against Article 1911.
We'll get into the details of that.
Yeah.
But in your own address to the court,
yes,
You told the court that if you do not agree with me to refer the matter to the Supreme Court, you said alternatively, that's the word you use.
Yeah.
That means you anticipated that the judge has the power to agree or disagree with you.
That is the way that every sensible lawyer will argue. Because there are two scenarios. Either the judge will comply with the Developmental principles and make a referral to the Supreme Court, or the judge could say that it is plain and clear, I'm not going to refer anything. Then in the alternative, look at what I've proposed as my written address. Because something, it would be very, very, very unprofessional of me just to have addressed the court on the issues of constitutional matters and leave, excuse me to say, equally important submissions on the charges and arguments pertaining to them, unattended to it. And I think that will be very, very
I'll go to Inusa. Sorry, forgive me. But a few things I need to clear with you from the very, forgive me, from the very, commencing statements that you made, confirming your earliest position that these courts, where the criminal prosecutions of the prominent cases, politically, exposed persons are ongoing, appear to be in an ambulance mode.
That is so.
And that the courts we normally know can give adjournments 2 months, as you say, and so on, but here they are not allowing that to happen because they are in a hurry.
Yes.
Is that not what we have always prayed for? That we do not have situations where cases are unduly delayed. In fact, Godfrey Dame Yeboah Dame was proposing a legislation where these criminal trials will be held on a daily basis.
Yes. You see, I've made an assertion I want to repeat. Justice hasn't gotten a political term of 4 years. And therefore, if justice is being run as if we want to have a political term of 4 years, then we have a challenge. I don't believe in undue delays. And equally, I want to argue that I also don't believe that justice is being hurried. For what? An end to placate where? Jubilee House. I don't believe in it. Because, for instance, are you sure that where a judge has not heard arguments on the need to make constitutional referral, which is, excuse me to say, at the very heart of the case, and it could turn the case one way or the other, the judge said, don't move this motion because I've captured your thinking already and it's embedded in the judgment. Do you know what that means? I have made up my mind. Don't disturb me with the law. That's what it means. And she comes around with a prepared judgment and delivers it.
Not comes around with a prepared judgment. A judgment whose date was announced in advance.
Yes.
A month or more.
Yes.
And it is the expectation of all parties, all players, that the judge will be writing the judgment.
Yes.
So writing the judgment is not sudden.
I understand that.
Right. If you say these cases don't have a lifespan of 4 years or political life cycle, some people will disagree with you. Why? Because already we are hearing that if you are not successful on appeal and so on, and the NPP wins power, Wontumi will get a pardon to be released. We saw the Opuni line of cases.
Yeah.
That took 7 years. They didn't finish. The Attorney General came. What did he do? Released all of them. Stop all those cases.
Yes.
So Ghanaians are becoming aware that that statement you made is not true.
I'm afraid they are being political to the point that they want to subordinate the judicial process to their political pleasures and appetites. And therefore they are saying that, can you aid us and hurry justice so we jail our political opponents? Is that the rule of law? And the judges should guard against that. If the judges are in an ambulance mood because they want to appease the political, government, you know, to achieve their political ends, then I'm afraid to say,
okay, so
the rule of law is undermined.
We'll get into the substance.
Yes.
You know, sir, what do you say? Your reading of the judgment.
No, first of all, I'm just, I'm surprised and worried that my good friend, brother, when we were in Parliament, he gave me a book. That book still stays with me.
Okay, so he has a habit of doing that because he's a voracious reader.
Yeah.
Even 2011 thereabouts, when I was going to court, he'll be reading different books, not law books, and he would show you that this book is good, read it.
Read it.
He's handed me a couple of them.
Yeah, so you see, my difficulty is that as a senior lawyer who was involved in the case, he's offered himself to discuss the matter on TV.
This is functus official.
No.
The judgment has been rendered.
He's indicated.
Everybody can comment about it.
He's indicated his intention to appeal.
Until appeal is filed, the matter is out there for the public.
So when I came and asked him, well, will you file an appeal? He says, I'm in the process. So that's my difficulty. But let me say first of all, let me say that Wontumi is not a political prisoner. And everybody should disabuse his mind on that statement. He is not a political prisoner. Wontumi is a common prisoner. He's a common criminal. Political prisoners are imprisoned because of their beliefs. I don't even believe and think that Wontumi understands the neoliberal philosophy of the NPP. I don't even think he understands.
Oh goodness.
Yes, I don't think so.
Answer, you should withdraw that.
I won't withdraw that.
The chairman of our
I say that I don't think. It's my view. It's my view. And how can you say that somebody who has been held by a court of competent jurisdiction to have violated the laws of the country is a political prisoner? What beliefs was he fighting for that sent him to jail? What was his ideological persuasion that was contrary to the existing governance arrangement that sent him to jail? He could not have been a political prisoner. Why? I mean, what was he tried on in court? So, please, see, as a country of laws, and I'm happy you mentioned the rule of law. As a country of laws, in a country that is intended on ensuring that at least there is civility in our engagement, there is honesty in the way we relate to facts and issues, we should, yes, you might not agree, I might not agree, but that doesn't mean that we should label a common prisoner as a political prisoner. No, he's not. He's not a political prisoner.
You see?
Two, the second thing is that, in addition to a line of cases that the judge cited, I will draw your attention to the Quality Green case. You remember, I was a junior counsel in that case. Section 179, causing financial loss to the state. We raised the issue. What is causing financial loss? What is the definition of financial loss? What's the definition? The penalty had been provided, but what is the definition? What activities do you do that we can say you have caused financial loss? If you set out honestly to do something and you apply diligence into doing that, and that thing turns out the other way, not to work, have you caused financial loss? Because intention is part of proving a crime.
Because the law is actually willfully causing
intentionally causing financial loss. What did Afraid tell us? He said, oh yes, so I've listened to you, but I'll address that in my judgment. He didn't escalate the case to the Supreme Court. He didn't.
The fact that you did not disagree with him does not mean that Atacha is not entitled to disagree with.
I'm addressing it one by one. I'm addressing it one by one.
Okay.
Now, when you raise an issue of a statutory provision which appears, and that is, I've cited this particular quality green matter to draw attention to Article 1911.
Yes.
Which is a fundamental right of an accused person. Okay? So the crime must be defined, the penalty prescribed in law.
Yeah. Written law.
Written law. You understand? So it's a fundamental right. Now, but this is how the court treated it. Now, because it's a fundamental right, the second leg, if the court ignores it, if the court refuses, neglects to address and avert the mind to Article 1911 in arriving at a conclusion, you have a course of action.
True.
And we all know that emotional discharges does not invoke the jurisdiction of the court.
That's a brilliant one.
Yes, we all know that. Okay? It doesn't invoke the jurisdiction of the court. If you think that this is the law and a fundamental right of an accused person has been violently violated, you know what to do. And the system of justice that we run is not like one-stop shop. If you go and you don't get it, that's all. If you go to the High Court, her Lordship, Audrey Kokofite is one judge. And that's the wisdom of the court system. When you go on appeal, they no longer trust the justice, that only one person should decide the matter. 3 heads are better than one.
That's right.
And so when you go, if again you exercise your right to escalate to the Supreme Court,
you are preaching to the converted.
Good.
You call them the 3 wise men.
Good. So
but,
you see,
Justice Sakabwa calls them
my good friend,
the 3 amicus.
3 amicus. So yes, so there's a remedy. Now, and I read, when you filed your defense, I read portions of the defense. I said, what my colleague is doing is right. He says, look, in the alternative, he knows that this is his argument. It's a legal argument. But that argument does not make it factual. Okay? In the event that his argument does not find favor
precisely
with the court, he wants the court to avert its mind to whether or not the essential ingredients of the offense had been proved in the trial. Again, both are appealable, are grounds for appeal. Both. So the noise that greeted the conviction of Wontumi and the indecent attempt to make it political is what I simply do not understand. Because you know that there are remedies. And
in very plain terms,
yes,
the term political prisoner does not apply at all.
At all.
Do you think that the press conference that was held that used political prisoner and the subsequent one, by that time they had not read the judgment yet? Is that what you think?
Well, it could be so. Because the judgment was 59 pages.
Yes.
But that's not too much.
Yes, that's not too much.
Yeah.
But the press conference followed immediately on the heels of the judgment, of the conviction. Yeah. And I don't know who would have read 59 pages to go and sit down and draft a press statement. And then they pick portions. Say, oh, Wontumi had a lawful concession. And as a former lands and natural resource minister, let me state that when a license is given to a person for the exploitation of natural resources, the exploitation must be done in accordance with the terms and conditions of the license. You can't take the license and do, because you have a permit, you then do as you please on that, in extracting the concession. So that argument that, oh, he had a permit, should not be an argument that should be advanced by people who understand the law. That it's the same thing. You have your house. You decide who must be your tenant. You enter into a tenancy agreement. You say that if a third party is coming into your house, that third party, so if your tenant is going to sublease, that third party must seek your consent. It's for good reason that you do that, because you want to determine who lives in your house. So whether there is an assignment or not, okay, what happened? Who had custody of the concession? Who was the rightful owner of the concession?
You're looking at the criminal matter as if you are dealing with a simple contract. As to whether somebody says go and do reclamation, he has he has a menstrual that should convert into doing illegal mining, and these are matters that are born about this.
So actually, the entire conviction turns on this.
Yes.
So I'm listening to the argument the two of you are having.
Yes. So let me first of all, Samson, address this. This is your being a political prisoner. You see, when you leave all the thinking in the realm called Ghana to lawyers, you say that's backlash, because we know that what happened in the courtroom was a criminal matter, and then they have lawyers, and then they came to the conclusion.
Yeah. But let me criminal matter which had nothing to do with his affiliation with a political party.
Precisely.
Not even affiliation, which had nothing to do with ideological and political persuasion.
That is fine.
That's how
or political activity.
That is fine. Yeah. That is fine. So the political prisoner issue is evolving from what they call the judgment of the people. What is it? If you fetch the chairman of the NDC in the Volta reading, and then maybe, I don't know who the Attorney General is, and then the Attorney General said, look, you have been doing Galamsey matters in the face of a situation in which the nation is awash with Galamsey. I want you to understand how they also see their perspective. I'm not validating it, but that's their perspective.
Are you suggesting that because one belongs to a political party, for example, if they've gone to rape somebody, defile somebody, and they are taken to court and they are imprisoned, we should say they are political prisoners?
Ghana is not awash with rapists.
Oh, really?
Listen, but Ghana is awash with Galamsey. Let me make this point.
First, let's put the thing. You are talking as if those who said the prosecution conviction was political,
yes,
and that Wontumi had transformed from a common criminal to a political criminal, we're not ordinary Ghanaians. We're not.
Listen.
So, first of all, no, let's not create a narrative. We seem to suggest that people outside common people saw what happened as political. As political.
No, those people.
Those who led the accusation were members of parliament.
Listen.
And the general secretary of the NPP.
They are projecting the thinking of the political following. Listen, this is what they are projecting. And Samson, if you give me a minute, because this is this is just not. You see, Samson, if you did that and you fetched an NDC regional chairman of the Volta region, and you secured the buy-in of two individuals who are accomplices to come and testify against him, and given all the circumstances, and we know that serious Galamsey activities are being done by the political operatives of this regime, what other conclusion do you want people to come to?
Oh no!
That you've singled out. Listen, listen.
Again, that narrative.
Listen.
You say, first of all, again, let's go back. So you know that we know that Galamsey is right, and on this platform we had said that one way to deal with Galamsey was to go after the big fish. And on this platform, we said it, and that look, Ghanaians, immediately we go after the big people. We will be sending a signal that we will go after you if you are found doing Galamsey, no matter whose axe is God. We said it here.
So if this is your sacrificial lamb, it's fine.
No, it's not.
But let me tell you what is going on.
Again, it's even wrong.
Yes.
Again, it's wrong.
No, cancel. Let me tell you.
The evidence implicating Wontumi in this matter did not start in 2025.
Does it really matter when it starts?
Matters.
It's a packaging. Listen. So Samson, what I'm saying is that it is very obvious to some people that Wontumi has been prosecuted, given what I'm telling you, that there are several MMDCs and the rest of them who blatantly are doing galamsey in the backyard, and they are not before the courts.
All right. So
if you want to do selective prosecution, they can come to the conclusion that you are doing political, cases.
Some say it may be too early to say selective prosecution. Yeah. But now let's get into the judgment. Okay. So the operation of the state entities that led to this, I'm going to get to that narrative and bring you in for you to address the first issue and perhaps the second issue, because we can agree that all the charges, you can synthesize all the charges into two. One, assignment of mineral rights without approval. That's contrary to section 14(1), which prohibits transferring, assigning, mortgaging, or encumbering a mineral right without written ministerial approval, and section 99(2)(b) of the law. If you categorize it this way, you would have taken care of counts 1, 2, and 3.
Yes.
Then counts 4, 5, and 6 come into purposely facilitating an unlicensed mining operation, contrary to section 99(2)(b), which creates the penal liability for aiding, you would disagree a bit there, aiding, facilitating or promoting any breach of the act where no specific penalty is listed. So for our viewers, I want them to do this for us. Then we address the first leg of assigning the mineral rights without the minister's approval, which is required. This is how the Samurai Boy operation was done. That led to the seizure of things. By the prosecution, they say that on April 16, 2025, police officers embarked on an anti-galamsey operation in the Samurai Boy forest within the western region. By the next day, the 17th of April 2025, the team arrested one Michael Jedu AC. Pay attention because that is coming up. Michael Jedu AC was the prosecution witness 1.
Yes.
You will hear them refer to him as PW1. Many have referred to him like that, PW1, PW1. So the police arrested him together with 28 workers occupying a fiscal structure bearing the bold corporate name of Akonta Mining Limited. Remember, Akonta Mining Limited is the third accused in this case. And Akonta Mining Limited is set up by Bernard Entry and one Kwame Entry, who is at large. The two of them are directors in this company, and they form that company. So on this day of 17th April 2025, the law enforcement seized an array of equipment and contraband. They included 25 serviceable excavators and 4 non-serviceable excavators, 8 pump-action guns, 1 single-barrel gun, and 310 AA/BB cartridges, 5 pieces of metal suspected to be gold contained in a sachet. Normally, when you go to a place where they do gold, that's how they do it. They put the gold into some small, sachets. They also seized 4 motorcycles, 2 vehicles, water pumping machines, a grease gun, 4 machetes, and an amount of 157,000 Ghana cedis cash. Now, during their interrogation, the police who arrested these people, Michael Jeduesi, PW1, named one Henry Okum. Pay attention, Henry Okum comes up central in this case. Henry Okum is PW2. As his employer, who directed operations on the concession. Following his arrest, Henry Okum, so because he pointed to Henry Okum, they went to arrest Henry Okum as well. Following Henry Okum's arrest, Henry Okum disclosed that in September 2024, he struck an oral arrangement with Bernard Enchibuesiako, who is the first accused, A1, to enter Akonta Mining's concession, that's Samra Boy concession, to extract gold from unmined portions of the concession, while using part of the gold proceeds to fund land reclamation. This is his allegation against Wontumi. Specifically, he said Wontumi asked him to plant coconut seedlings on the degraded and mined out areas. Then, when you go to the police like that, you will give a statement. So in his statement, which is called the caution statement, and his witness statement, Bernard Enchibuesiako, who is now in jail, admitted, he did not deny this, he admitted to granting a verbal permission to Henry Okum, PW2, but he asserted that his authorization of Okum was strictly restricted to land reclamation. He maintained that PW2's gold mining activities were unauthorized and conducted without his knowledge. This is where we come to hear how they go about it and how the court resolved it. What were the key evidence used in this particular charge? So to resolve the case, the court isolated what you call the essential legal requirements for each of the charges and evaluated the evidence to determine whether those legal tests were met beyond a reasonable doubt, because it's a criminal trial. And this is how the court went about the resolution. I think I'll skip that and have them speak so that I avoid talking too much.
Okay. With the greatest of respect to the judge, I believe that her understanding of the assignment, is self-defeating. In the first instance, that assignment is a legal arrangement, because every assignment of a mineral right should seek the approval, or should have the approval of the ministers. And a former minister is here. I do not believe that the minister will approve of an assignment of a mineral right when the so-called assignment is an oral engagement. Ministers do not approve of oral contracts or assignments. What the ministers do is that there should be a clear-cut case that, somebody has a mineral right, a concession holder, and wants to give it to another person. So therefore, the requirement of writing is very essential in this case. And guess what? This case was bereft of any writing by way of an assignment. It was a case of your word against mine. Go and work on the concession and do reclamation. Plant coconut seedlings as much as you want to do. And when there's a harvest, we split, 50-50. So therefore, if the judge should say that the mere fact that PW2 and PW1 went on the concession is equal to an assignment in law, I beg to submit that that argument is not well grounded at all. And if they went to the concession by reason of what Wontumi said they should go and do, and they did otherwise, and this is my chief concern. that if Wontumi wanted them to do reclamation and they decided to go and do galamsey, how do you impute criminality to Wontumi? And guess what? If you have a farm, you made the farm owner, and you send hirelings to go and work for you, doesn't mean that if, excuse me to say, assign your interest in your farm to them. But the sheer fact that they are working on the land. So a worker on a concession hasn't got an assignment. The right of the concession still resides in the third, accused, the company, Akonta Mining. So I want to submit, with all respect, and I concede the fact that we are not in the appellate court, but the treatment of assignment in law by the judge, it's one of the areas that we believe the Court of Appeal will take a look at it.
So, for the purpose of this discussion, I'm tempted to do quite a bit of reading because of the chatter and the noise that has been in the public. And please bear with me because it's important for us to discuss this within the evidence and the facts. So, the judge began his resolution of this matter by admitting that whether or not Wontumi gave Henry Okum, PW2, permission to go onto the concession is not disputed because all of you agree that he gave the permission.
Yes.
The contest is whether the permission was to mine or to reclaim.
Yes.
And as you say, and the judge admits that it was not in writing.
Yes.
And there was no witness
yes.
to this kind of arrangement. It's just between the two of them.
Yes.
So that's why you say it is the judge is taking the say-so of that these witnesses. So the judge comes to page 23.
Yes.
And says the arrangement that Wontumi had with Henry Okum is not documented.
Yes.
It's not documented. There is also no witness to the discussion which resulted in the arrangement. So there is no direct evidence on the matter.
Precisely.
This is a judge being very candid, right?
Yes.
And dealing with the facts as they are.
Yes.
There's no direct evidence on the matter. Then she says, whereas in this case, direct evidence is lacking on a matter, a court of law is entitled to rely on circumstantial evidence. Then she quotes a number of authorities.
Precisely.
Please let me read one where she says, it is quoted, circumstantial evidence was evidence of surrounding circumstances which by undesigned coincidence was capable of proving a proposition with the accuracy of mathematics. In criminal cases, it was sometimes not possible to prove the crime charged by direct or positive evidence of persons present at the time the crime was committed. So where the testimony of eyewitnesses was not available, the jury was entitled and indeed permitted to infer from those facts which the prosecution had proved. Entitled to infer from facts which prosecution has proved. Other facts necessary either to complete the elements of guilt or establish innocence. However, before drawing the inference of the guilt of an accused from circumstantial evidence, it was very important to make sure that there was no other coexisting circumstance which would destroy or weaken the inference. That circumstantial evidence had to be closely examined and acted upon only when the circumstances were such that the guilt of the accused had of necessity to be inferred and that the facts led to no other conclusion. Then she gives you further cases. No, wait.
I think that's the Wilmington and DPP.
She gives you other cases. This is Dria. She's quoting from Dria.
She's quoting from Dria.
Then she gives you other cases to still talk about these things. Then she comes to the point.
But Samson, I beg of you, with the greatest of respect.
All right.
You see, there is a critical case that she quoted but never applied. So flowing from what you said, that is the Anani Fiajo case. Right. And then read it very carefully. A presumption from circumstantial evidence should be drawn against an accused person only when the presumption follows irresistibly from the circumstances proved in evidence in order to justify the inference of guilt. The inculpatory facts must be incompatible with the innocence of the accused and incapable of explanation upon any other rational hypothesis than that of guilt. I'm going to apply this to show.
No, wait.
Yes.
Because there's no direct evidence.
Yes.
How did she come to the conclusion that the circumstances from the witnesses that have been given was sufficient to hold that Wontumi, who was identified as Akonta Mining, because they had come to the conclusion in the process that Wontumi was in fact Akonta Mining. Akonta Mining was Wontumi, because everything he was doing, all the people who came to testify said
never been a board meeting.
They engaged with Wontumi and all, and he's the one who did everything.
Yeah.
So, number one, they find, as the witnesses show,
yes,
the guy says, I'm a small-scale miner, number one. I'm not a reclaimer. So if you say I should go and do reclamation, doesn't make sense. I am a small-scale miner. Number two, Wontumi says, I don't know that he's a small-scale miner.
Yes.
The one who says he's a small-scale miner and the one who says he's not a small-scale miner, the judge is entitled to take a view. And then it is found out that Henry Okum has actually been doing small-scale mining for years. At least it's 7 or 17 years.
Yes.
7 years. Then he asked the question. He said, Wontumi didn't give him money. If you have employed me as a reclaimer to do reclamation, you didn't give me money for it.
Yes.
How was I going to do it?
Yes.
You also helped me to procure excavators, equipment, to go and do this. What was excavators for? People are asking questions. 20, how many excavators? 50 something or so. 25 excavators. Actually, not 25, 29 or so. Because there were 25 that were serviceable and 4 that were not serviceable.
Yes.
So people ask the question, what was the excavators doing? Again, it is shown that Wontumi, on his own company letterhead, makes an intervention for security protection for the work that Henry Okum and his 28 workers are doing. What was that protection for? Protection to reclaim. So she goes through all the circumstances and says, the circumstantial evidence point to this thing.
But it doesn't, because
and
there is
I don't know if you are you.
Let him finish.
Yes, you see,
let him finish.
You see, because there is another rational hypothesis which inures to the benefit of Wontumi. And let me explain.
Yes.
First of all, I believe that the judge was trying to surmise. And in criminal, evidence, surmising can be your, if you like, your rational thinking, independent of mens rea. Why do I say so? I don't believe that when we are doing reclamation, you should use hoes and cutlasses. So the sheer fact that they are doing reclamation and they are using earth-moving equipment is not conclusive of the fact that Wontumi sanctioned mining on the concession. I want to say that clearly. So the machine should not give you the pictures and the imagination that Wontumi has sanctioned illegal mining. Second, the judge did not realize there's a lot of money in reclamation insofar as you plant the right crops and check out the monetary value of having a whole acreages of coconut for harvest and sale. So the judge did not even bother that there's a financial reward for what Wontumi did, not in terms of mining, but rather reclamation. So therefore, if you want to prefer one version against the other, then this is where I have the biggest problem. And let me explain. The evidence is showing that PW1 and PW2 were accomplices. They were arrested and they were brought before the same judge and they were admitted to bail. Now the Attorney General, as he's been doing, in my case he's done it, trying to convert accomplices into prosecution witness. Went into non-prosecutorial bargain with PW2 and PW1 that we will let you go and you will not be prosecuted and come and testify in this case. It is clear as daylight that these people were candidates of a prosecution and then they were romanced into becoming prosecution.
Is it allowed in law?
It is allowed in law.
Okay.
It is allowed. I agree that it's allowed in law. I do not see in the circumstances of the case that PW2 who went into this bargain and now is not telling everybody that he licenses me to go and do this thing. Who say, oh no, Council, let me finish. Council, let me finish.
First of all, even there was a fundamental question that the judge did not avert her mind to. Was Harry Okum a trespasser onto the land?
No.
So what is the liability of an invited person onto land? Who bears liability for that?
He went there with permission, and all of them agreed.
And the permission was not a criminal permission.
Again,
he went there with permission. PW1, who is his employee, and the 27 others who were all there, they are there on the permission of Wontumi.
Listen, was not a trespasser onto the land. That's
correct.
That's what we
listen.
All right.
Listen.
So what's the point? He's not a trespasser.
So he got there at the invitation or permission of somebody. That was Wontumi.
That's right.
He did certain activities that were unlawful.
Correct.
Okay.
Because Wontumi said he didn't know that he was doing those activities.
Yes.
The concession owner was Wontumi.
That's correct.
Yes. Wontumi Akonta Mining invited him onto the concession to, according to him, to do certain things. Herokum was doing
other things.
Yes. You know, so you are arguing that Herokum having been invited onto the land to do something and was doing some other things, Wontumi had no obligation.
There's no mens rea.
Because Wontumi says he did not know.
Yes.
Oh, the fact that you did not know, the fact that you say you did not know, does not, in fact, mean you did not know.
Of course, the judge said, you claiming you don't know. Yeah. You are the same person who called for security protection. And the whole Western regional security arrangement was marshaled to go and protect these people working for you. So how do you come and sit here and say you didn't know? You never visited?
Listen, the second thing is that when the security went there, they didn't see coconut seedlings. It's all good.
Oh no! Please. Oh, you see, they arrested them. Listen carefully. Not that the coconut plantations are there now, but they arrested them doing illegal mining.
Yes.
Question as lawyers. Let's.
They have seen coconut seedlings.
Oh,
but they didn't see
the reclamation was there.
Oh, they had planted coconut at some place.
Please, back.
No, they had planted. What I'm saying is that in their accounts,
yes,
you don't read. And we are looking at the records of the court. You don't read that when they went onto the land to arrest them, they found coconut seedlings.
They were doing the illegal mining. But who authorized them to do the illegal mining? There is a necessity for a mens rea that this individual said, go and do reclamation, and they did otherwise. Where is the criminality? But let me show you a more.
You don't think the judge got the mens rea? All the assistance that
it was not present because
they are using your equipment, they are in your own facilities, there's money there,
and your invitations and permissions. And then let's come to
it's okay. Please hold on.
Let me finish.
We started with assignment.
And we are still on assignment. Hold on. Yeah.
And therefore, there is an alternative rational hypothesis that indeed and in fact, Wontumi said the gentleman should go and do reclamation, and they did otherwise. Now, there's a problem here in law. Mm-hmm. The problem is that when a witness who is an accomplice is testifying, the law says the judge should be very cautious of the evidence of the witness who has bought insurance to come and testify so that he's not prosecuted. And that caution is for one simple reason, that the man cannot testify against himself. And he can also not testify against the position of the Attorney General where they've signed a plea bargain. Very important. What is even more important is that the law enjoins a court that you need collaborative evidence. Something I can show you the authority.
In the absence of collaborative
of course.
Let him finish.
Of course, in the absence of collaborative evidence, where you have been converted from
and we keep in mind that even the Deputy Attorney General has conceded what is in the judgment.
Yes.
But for these people, the case would not have won a case against them.
Precisely.
Bottom line, that's what he says.
Yes.
When he says that the evidences that were relied on, everything was Wontumi's own evidence, which includes his own people who were working for him.
And even something that what is even more serious is that the Attorney General is now conceding that the judge should have upheld the submission of no case.
Really?
Yes, because he's saying that now Wontumi is being convicted on the evidence of who? Not that they produced on his own evidence, and there's no evidence that the Attorney General produced which is strong in itself, more so when you've brought in accomplices.
Okay, these comments are in the public.
Yes.
He didn't make them in the courtroom.
So
go on to where you are going.
So let me just give you an authority. He knows all these things, but sometimes, they want to ignore the law and do other things. Listen, pay regard to a very, very seminal case of Obin versus the Republic.
Right.
And the court was so strong on this matter. I think, with respect, that the learned trial judge erred in failing to direct the jury to consider whether Georgina Owusu-Efie was on the evidence and accomplice, where in the seminal matters are suggested as being corroborative, which in fact are not, and therefore it is in fact no corroboration at all. The conviction may be quashed on appeal. You see, what the law, and there are several. I don't want to detain you with all the authorities of the Supreme Court, but let's come out clearly with this. Apart from what PW2 said, there is no corroborative evidence that would to me sanction him to go and do illegal mining. There's none. I've perused this 59-page judgment.
Corroborative evidence, but you have more than one person saying the same thing.
Who else said it?
PW1 and 2.
Listen, the man who brokered the deal is who?
Even their own witness they called.
Yes.
What's his name? Is it Gomashi or somebody? Yes. Their own witness they called. Ended up giving evidence that the judge used, which obviously is against them. Because he came to testify about the expensive nature of reclamation, and you cannot ask somebody to go and do reclamation without giving them money.
Listen, that is a conjecture. And yes, and it's a bargain.
That's an expert witness.
Yes, the expert witness said.
How do you expect to pay the
listen. That is their bargain, and that is not criminality. A man says
that should prick your mind.
No, listen. A man says that I am ready to go and do reclamation
because of
grow coconut seedlings, and let's share the profit 50-50. In the mind of the judge, that was a poor bargain. But the judge is not supposed to rewrite bargains in the criminal matter. And that is what is very important for us.
You seem to suggest that mens rea cannot be inferred, but that's not law. You can infer mens rea, and that's what the judge says. The circumstances leave.
I'm not saying it cannot be. You cannot impute. You see, you are trying to say that he had a criminal mind. He's saying that I didn't have a criminal mind. Why? I never sanctioned this guy to go and do illegal mining.
Let's hear the judge. On page what's this?
Let me do.
You hold on. Page 28. I'm at page 28. Page 28. The judge says in paragraph 6 of his witness statement, Henry Okun stated further, quote, "I funded the reclamation works using proceeds from my mining operations on the concession."
Yes.
And Wontumi was fully aware of this fact, end quote. Then the judge says, Henry Okun was not cross-examined on this critical piece of evidence.
Yeah.
Neither did Wontumi put before the court any evidence to show that he had advanced money to Henry Okum to fund the reclamation. Thus, Henry Okum has maintained throughout the trial that Wontumi had permitted him to do two things in the concession, namely to mine for gold and then use part of the proceeds to reclaim the damaged land.
Yes.
In fact, during cross-examination, when Henry Okum repeated his claim, counsel for Wontumi and Akonta Mining did nothing about it. So this is what happened. I need to mention that. This is a question was asked. Were you able to extract some gold in your operations? His answer was yes, of course. That was my aim of going there.
Yes.
Question. And when your staff were arrested, that's the 28 others who were arrested, when your staff were arrested, they took away some amount of gold. Is that correct? His answer, yes, my lady. Question. And this gold was not from illegal miners, but from your operations. Answer, yes, my lady. Now, this is how the judge asked a question. The nagging question at this stage, following from this testimony, is why any person of sound mind will volunteer to reclaim a tract of land deep in the forest that has already been mined by another at that other person's own cost and at no cost to the other one who has asked him to do the mine, the reclamation.
Yes.
More intriguing is that this person alleged to have offered this service gratuitously is a small-scale miner with no previous experience in land reclamation, assuming without admitting that a person of sound mind would even agree to enter this alleged arrangement. Henry Okum has expressly, emphatically, and consistently refuted the claim that he ever agreed to it. Having rejected the allegation, the burden rests on Wontumi to lead evidence on the probabilities to show that Henry Okum had agreed to the alleged arrangement. No such evidence was, however, led in this case. What did you want the judge to do?
You see, even there is a fundamental error that now we leave the realm of proof beyond reasonable doubt and come to probabilities in civil cases. This is the poverty of the judgment.
No, the probability
Listen,
used there.
Counsel,
The probability used there is reasonable doubt.
Look,
the probability.
Look,
it's not proof beyond reasonable doubt. It's probability, the reason of doubt.
Counsel, I'm saying that
the arrangement, yes.
I'm saying that there is a whole aberration in trying to raise the issue in probabilities rather than a reasonable doubt. Because the authorities are clear. The burden of proof is
reasonable doubt.
No, the authorities are clear that there is
no burden.
There's no burden on.
To displace the burden of proof of reasonable doubt.
I crave your indulgence. Listen. There is a doubt raised. In the sense that, look, if you do not assess the value of reclamation, and if you do not understand that you are not supposed to conjecture as a judge in trying to look at the bargains of the people, how poor the
inference or conjecture?
It is a conjecture.
It's a judge entitled.
Yes,
Mr. Atacha. It's a judge entitled.
Yes,
it's a judge entitled to also consider a witness in his whole.
Yes.
A witness or an accused who says, I employed him, but I didn't know he's a small-scale miner. The guy says, I'm a small-scale miner. That's what I've been doing for years, and he knows.
Yes.
Then, to help him to procure machinery, including excavators, okay, the question is being asked, what for? In those numbers. Hold on. Reclamation by seedlings and coconut trees. Now, Wontumi again sets up this company, the third accused, with Kwame Entry, right? Kwame Entry, where is he? Wontumi says, since 2021, 2022, he said he was going to travel. I haven't seen him since. Your own partner in a company, you don't know anything about him, you can't find him. Do you think the judge is allowed to disbelieve Wontumi and believe the other witnesses?
Yes, because there is an alternative rational hypothesis, that does not lead irresistibly to that conclusion. Let me finish.
When he finishes, you come in.
Yeah, please. So therefore, if in the mind of the rational judge, Wontumi's tendencies are not economically sound with that amount of criminality, you should look at it critically. Is the judge entitled to rewrite the bargains of the people? And let me tell you something. There is no incentive for PW2 to speak the truth, because he has signed his insurance that go and testify against Wontumi for your freedom. What were you expecting? Did the judge place anything on oath against oath? And also, when you need corroborative evidence relative to what an accomplice you say, this is at the heart of the case. And I'm very, very sad in that. The judge was...
The corroborative evidences you are talking about.
Yes.
The judge points out to you that Wontumi and Akunta Mining, they called how many witnesses? 5.
Yes.
Out of the 5, she says 4 of these witnesses confirm that Wontumi does not do his things in evidence writing. He does it orally.
Yes.
What else? So it is oral evidence that she will use.
And that is even more serious. That the oral evidence is one of an accomplice against Wontumi. And the accomplice has bought his insurance for freedom. Who should you believe? And the law says that Supreme Court decisions are saying that there should be corroborative evidence relative to what? The critical engagement. Now nobody was there. It was between PW2 and Wontumi. All the other people were not there when they were doing the bargain. And one of the things that has been lost on, everybody is that, are you saying that you can't make money out of reclamation and the harvest of large scale coconut? Are you saying that? So why are you saying that it is not probable in your thinking? And that is a very sad conjecture that the very authorities on circumstantial evidence does not permit a judge to do.
Yes,
you started by assignment.
Don't you think, importantly, that they raise the question of the assignment, which must be evidence in writing?
Yes.
And there is nothing like that.
So what is the procedure? So you have a concession, and you want to assign rights, your mineral rights in that concession to a third party. What do you do first? You write the assignment.
That's so.
No.
What do you do?
You seek approval.
You know what is
what
that?
they are telling you in their defense. What they are telling you in their defense, that as far as this particular charge is concerned,
I'm telling you the procedure.
As far as this particular charge is concerned, they are saying throughout the case, you can see that was their defense strategy. That to the extent that there is no document evidencing an assignment, that charge is dead.
So you have mineral concession and you want to assign to a third party. The first course of action open to you is to write to the minister informing him that you are engaged in discussions with a third party to assign your mineral rights. Now that is first. Not doing that alone cannot even entitle you to assign.
So then they
are saying that they did not assign mineral rights. Wontumi simply engage somebody to go and do reclamation. That's what they are saying.
Oh, then I'm trying to explain to you. They are using the technical meaning of assignment to try to defeat the argument. I'm saying that you cannot jump into assignment. The fundamental thing is, if you want to assign, and so it's right to say that we didn't assign because you didn't write for approval to assign. It's right.
So
you understand? And they did that deliberately because it was an illegal activity that they were engaging.
How do you say this?
But it's true. First of all, you want to assign. You say that assignment must be in writing. You say that. It must be in writing.
Yes.
But because that is law. They are not the ones saying
no, he says that. It's law. But the approval, seeking approval from the minister must also be in writing.
It didn't start at all for anybody to go and seek approval.
But you don't see that it didn't
start at all.
But you didn't see that it will start.
The assignment was not present to go for a ministerial approval.
You didn't see that it will start.
Yes.
That was the criminal intent.
What was the criminal intent here?
Because you
go and do reclamation.
Follow the law.
Oh, goodness me. Now you should show that
you didn't intend to follow the law.
You should show.
And so you entered into oral agreements to put a third party onto the land and come to court to narrate facts which clearly is not supported by what the third party was doing on the land.
The judge said even if Henry Okun's engagement was to do reclamation, reclamation must be done by, he should have done a certain registration or procured the license required for the reclamation.
Yes.
He didn't have that. He says, I don't have that because I am a small scale miner. I don't do this. Questions have been asked. If somebody admits to an offense like this, shouldn't they be punished? The judge says that provision, which says you must have a certain registration of or license before you can do reclamation. That law, that provision does not come with a punishment.
Yes.
So he goes free.
Yes.
They are asking you the question, why should such a person go free?
Because he's admitting to
wrong.
Well, for self-confessed criminals, we have got a lot. So you don't go there. Don't go there.
You've got a lot from where?
It won't benefit you. Don't go there. What I'm saying is that is for the state to take up.
Right.
That's not for me. And so, if a person commits a crime, the interest of that person against whom the crime has been committed, if it is an individual, is contaminous with the interest of the state. And so, the state must decide whether it wants to go after that person. That's why we don't have private prosecution.
That's why you talk about selective justice then.
No, that's why we don't have
Let me get accomplices to come and testify against the chairman of NPP in Ashanti region.
Professor Apieje Etua joins us, but I'm coming to you. When the judge says in page 54,
yes,
what I believe many have not paid attention to,
yes,
she says, page 54, the very last paragraph,
yes,
she says, the very absence of documentation is not a defense, but part of the informal and undocumented pattern of dealing this court has found to be the true character of Wontumi's conduct of Akonta Mining's affairs. A finding that a right holder cannot use his own default to defeat. So when you say I need evidence written, she says, let me read it again to you. She says, the very absence of documentation is not a defense.
It's modus operandi.
But part of the informal and undocumented pattern
modus,
which Wontumi's four of his own witnesses confirm. It's part of the informal and undocumented pattern of dealing that this court has found to be the true character of Wontumi's conduct of Akonta Mining's affairs. A finding that a rights holder cannot use his own default to defeat. So the fact that you don't have a document, you can't use it as your defense to defeat the fact that you have in fact done the thing. That's what she's saying.
In fact, I find it a bit weird to suggest that if you have a concession, you cannot give it to individuals to work on it. Like you yourself as a company should be working on it. That is what we should bear in mind. But if
really,
you can. It's here.
Where?
Yeah, I'll show you.
Where?
Yeah, what the law says. You see that you can do things reasonably necessary associated with the mineral right. Yes, is that in fact the judge quoted that?
Which one?
Let me get it for you.
I think he's talking about section 46.
Yeah, it's there.
But did that come up in the case? This is belated that people are, putting up section 46.
No, even putting a wrong interpretation on it. You read it, section 46.
Let me get you.
Assign without authorization. You can't.
You see, there was no assignment in the first instance. You see, Council, let's be clear on this. Let me try and
the interpretation.
Let me try and get you. I mean, a very important dimension. I found it very weird that if you're a concession owner, you can't do what is necessary to actualize. I mean, what you're supposed to do.
That is bringing people to do galamsey on the land.
No, he didn't do that. He didn't say that they should go and do galamsey on the land. But you can do what is necessary. Yes.
Actualize that.
Yes.
That's the terms and conditions of your license.
Of course.
That's not.
If you got hirelings to be working on the concession, are you not? Is it not necessary to actualize you having the right to go on the land and do your mining?
It's a contorted interpretation.
What's contorted interpretation?
Okay, so I take it that you are waiving reading section 46 because it didn't actually come out in the case.
It's true.
It is now that it's being raised. Now I'm going going to bring Professor P.J. Etua for his very brief comments. He couldn't join us earlier.
Yes.
His very brief comments on the way the judge went about coming to the conclusion. And I will do that once again with reading something from this paragraph. And you can see that I'm deliberately doing this because there's been a lot of chatter in the media without specific references to the content of the judgment. The judge says, it has not accepted Henry Okun's account uncritically or his oath alone. It has tested, that is the court, has tested that account against Wontumi's own witness statement. The Wontumi's own investigation caution statement, the unchallenged, uncontroverted evidence that Henry Okun, in fact, extracted gold from the unmined portions of the concession, the equally unchallenged evidence. So remember, she's talking about something. She's saying that, don't say I have listened to these people without being critical. She says, I've been very critical about it. And I have tested his oath, his evidence against Wontumi's own. Things he has admitted, his own witnesses have said. And she says, the unchallenged and uncontroverted evidence that gold was extracted from the concession.
Yeah, this one good.
And then equally, the unchallenged evidence by Henry Inkum that he funded the reclamation exercise from those very proceeds with Wontumi's knowledge, and the absence of any evidence beyond bare assertion that Wontumi ever advanced funds. So it is shown that Wontumi never ever advanced any funds for the reclamation. Then she says, verified Henry Inkum's claimed line of business, that he's a small-scale miner, or supervise the site to ensure that only reclamation, remember, Wontumi says he didn't supervise the thing, and no mining was underway. He didn't ensure that this was going on. It is that convergence of independently tested circumstances and not Henry Inkum's word alone upon which this court's findings rest. The submission is accordingly rejected.
Yes.
Professor P.J. Etua.
Okay.
Let's hear you.
Having listened to, well, not much of the discussion going on, but having had a time to read just portions of the judgment, I come to the conclusion that clearly this was a decision that was fairly decided by the courts.
Really, Wontumi is not a political prisoner?
Not at all. I think the whole idea of a political prisoner is totally blown out of proportion. There is no connection at all between what Wontumi did or what he has done and the claim that he's a political prisoner. If you're a political prisoner, it means that you have not committed any offense, but you have come up with some thoughts and ideas that challenge the powers that be, and therefore you are speaking truth to power and you are challenging orthodoxy, and you are making some claims on human rights grounds to promote democracy and human rights, which therefore does not accord with the position of the government in power, and therefore you are being silenced. And that is where, whether they put you in prison or they try to gug you or they try to force you out of the country to exile, that is where you can talk about somebody you can term as a political prisoner. So there is no way that we can term Wontumi's case as a case of political prisoner, not in any sense at all. And I think NPP went below the belt by drawing that conclusion. in my opinion, the decision was fair and square. It is a very good decision, and the judge took time, I think probably because of the political context in which the decision, the case came about, that she made sure that all the evidence is tested, and the decision that she came to is, I think, the right decision that should be applauded.
Like Yunus Hussaini here, there are some members of the public who are asking questions. 29 excavators found on this place and seized. What are excavators doing in reclamation? But you can't do reclamation of such a place that has been devastated by mining without excavators.
Oh, definitely, you will need excavators one way or the other. But it is not just the excavators. The overwhelming evidence indicates that some work was going there, which clearly showed that there was no authorization to mine a concession, and the issue about the evidence given that there was some work going on to reclaim the land, where in actual fact the work that was being done, the person is not being paid. So how do you get paid? You have to mine and do the illegal mine in order to get money to pay for what you are doing. And so putting all this together, I think it's clear that what Wontumi was doing was done in violation of the laws, the very laws which, interestingly, the then NPP government came to enact or to amend to make sure that people do not violate the laws of the land as an attempt to help protect.
But Prof, the question that is being raised is that this is criminal prosecution. Proof must be beyond reasonable doubt. Of course, we know the rule that beyond reasonable doubt, as the judge herself, is not unminded of, says it is not beyond a shadow of a doubt. Proof beyond reasonable doubt is not the same as proof beyond a shadow of a doubt. But where circumstantial evidence is required to convict a person, the argument is being made that the alternative could also be plausible, that he is simply unaware, despite all the information that suggests that he may be aware.
Yes, the issue of circumstantial evidence at a point in time it becomes very critical to resolve that in order to ensure that justice and fairness in the decision is recognized. And I think that with what the judge went through in coming to the conclusion that it points to a case of violation of the Minerals and Minings Act, I think it rests on solid grounds. And so for that matter, I think that we cannot fault the judgment in any shape or form. If you're looking at circumstantial evidence, you have to put a lot of evidence and factors together, and before you can come to the conclusion that this is, there's no other alternative decision or conclusion you can come to. Yes, it is possible that you can look at it from other angles and see that it is possible you could have arrived at a different conclusion. But the overwhelming evidence seems to support the view that the judgment was fairly done. The judge did a thorough job of ensuring that all the critical pieces that needed to be looked at were looked at. And for that matter, on that basis, the conclusion to me is clear. That
but Prof, I have a problem here, Prof, with the greatest of respect. You see, when you touch on the case in which the judge has pronounced that there is no direct evidence, and therefore let me go into the area of circumstantial evidence, all the authorities are very clear that you shouldn't come to a conclusion that is guilty if there is an alternative rational hypothesis.
Yeah.
Case. So therefore, what I'm seeing in this judgment is judicial, evidential, infailing. The bargain does not make sense to me.
The judge's view then is that the alternative is not convincing. That's the law.
No,
the alternative is not convincing.
That is the point.
It's not that convincing. It should lead irresistibly to guilt. So I'm saying that if a man goes to do,
yes, but the alternative that you are proposing is not raising doubt in there.
The alternative hypothesis is consistent with the innocence of the man. That I told you to go and do reclamation, and you did otherwise. Is it not a rational alternative hypothesis since the judge has made a finding?
The judge is asking you a question. The judge is asking a question. Will a rational man commandeer a whole regional security to go and protect somebody when he doesn't know what the person is doing?
Because of the gangsterism in this mining arrangements. Why not?
Mining.
So you think it's only in Ghana that you need protection?
You said he was not doing mining.
Yes. So you think it's only mining that you need protection?
The judge averted her mind to the fact that if someone is doing reclamation,
he doesn't need protection.
He doesn't need security.
You have been told by some other commentators that you can't fault this judge. Long before this judge came to handle this case, the Akufo-Addo regime itself had flagged Wontumi that what he was doing there, he was not doing it with approval. In fact, if you go to a 2019 judgment by Justice Ejie Frimpong, it was a civil case. But Wontumi was found to be doing illegal mining. He had commandeered 100 Chinese nationals doing work there. Was it 10 or 100? Then in 2023, another court, still in Second D, in Akonta mining case against Samatex, still finds that Akonta mining was there doing mining when he didn't have the right to do the mining. At the time when only he had a prospecting license, he was doing mining.
You see,
the people had complained over a long period, since 2012, 2013, and so on.
You are not permitted to backdate a crime. And let me tell you what is very critical.
The crime doesn't run against
you see, you are not permitted to backdate a crime.
Time doesn't run against
the evidence before this honorable court has not gotten anything to do with the past.
I agree with you.
No,
that's why I didn't bring it out.
Please.
Samson, in the 2013
we need to take a break and move to Kenoforiata's success.
Yes, but I just want to say that I just stayed away from that case. The 2013 case, I was in the minister.
Yes.
You see, don't
sued the Attorney General for $43 million.
Please don't import past issues into this case. We have a good case right now.
But are you concerned that in two different judgments, 2019, 2023, the courts found as a matter of fact that Akonta Mining Services, Benin and Chibuesiaku were engaged in illegal mining? Where? Samra Boy.
I am very much concerned. Illegal mining is not what I will bless. But what I'm saying that right before this judge, it's not these imported past events.
That's correct.
There's a recent.
That's why we are not talking about it.
There's a recent case in which a man says, "Go and do reclamation." And the man does illegal mining.
All right.
And let's say
I agree with you.
We don't
want to go to the past.
So that we want to impute criminality to the man.
Okay, thank you. Prof, maybe your final comment on this before we take this break and return to the matter of the Kenoforiata. Atachan believes that, of course, many lawyers have said this is a good grounds that he will be going on. Believes that, the preliminary points that he raised, that the provisions were not clear enough in the prescribing the punishment, and therefore asking the judge not to give a judgment but to hold on and refer the matter to the Supreme Court for a determination under Article 132. The judge should have done that, and the judge disagreed. What do you say about that?
I'm sorry, the line has been buffering, so I'm able to hear you very well.
Yes, Atachia said that the judge should not give a judgment. He should wait.
Okay.
Stay the judgment and refer Section 14.1 and 99(2)(b) of Act 703 to the Supreme Court under Article 132 because the provision vesting that's the provision that vests the Supreme Court with original jurisdiction over genuine questions of constitutional interpretation and requiring that lower courts must refer such issues. He argued that the statutory provisions that were used were unconstitutionally vague under Article 1911, right? And the judge said they are clear enough for her. She moved on.
Yes, I think I agree with the judge because even though the issue of I think punishment was not clearly stated in that particular law, it was referred to in another law, in another act, and which I think that it solves that gap that counsel Atacha is trying to argue that because of that, on that basis, it should be referred to the Supreme Court for interpretation. So I think that gap, which would have called for that interpretation, is filled by the reference to that law, which I can't remember exactly what. So in my opinion, that should end the journey to the Supreme Court.
Okay.
And should end the matter there.
Okay. Actually, she relied on a case that said that a trial court is not obliged upon the mere say-so of a party that a question of constitutional interpretation arises to down its tools and refer the matter upstairs. My cancan, he just referred to. We'll be right back.
She didn't apply as an author who says that do not graduate from a high court to a Supreme Court.
Yes, I said I was taking a break, but you are appealing this at all costs, right?
Yeah.
When are you filing the appeal?
Next week. Yeah, we should be able to do that.
Yeah.
Yes,
and when you file the appeal, you will file bail pending appeal.
Certainly, we'll do that. He will do that.
So you are hoping that he will not be in prison for a month before, you know.
I'm hoping that the judges should apply the law, and then we could get him out and contest the appeal. Yeah, because bail pending appeal is simply saying, look, if the appeal should succeed, I mean, that is it.
Okay. So if this doesn't succeed, it means Wontumi is going to be in jail for, if he conducts himself well in the prison,
good behavior,
he will be in jail for 13 years and 4 months.
On good behavior.
He will get a dash of 1/3 of the sentence. That will be 6 years and 8 months. But that is if he pays the cumulative 600,000 Ghana cedis fine that has been slapped on him and Akunta Mining. If he doesn't pay that, he goes to jail he spends another 3 years. But the prison calculation is different. We'll take a break.
Yes, we didn't address the critical issue of the sentence. Because as a first offender, Leonard, you should know that if you took him to 20 years, I thought you even consider the minimum.
Which is 15.
Which is 15. You see, so these are also feeding frenzy.
This one, you shouldn't complain.
No, you are talking about...
You were part of the majority who escalated it from...
No, you are talking about deterrence, and I'm saying that...
What I'm saying is that Attorney General Gloria Akufu came to Parliament with an amendment to Act 703 and proposed 10 to 15 years. When the bill landed in Parliament, Constitutional, Legal and Parliamentary Affairs supported the Attorney General. When the report was presented to Parliament, the majority led by my good friend Chieftaincy said the 10 to 15 years was small, and that we should escalate it to 15 to 25 years.
That's water under the bridge. I'm saying that.
You said. I remember President Akufo-Addo.
Yes.
He actually gave a statement at the time when he was waging the campaign against Galamsey.
Yeah.
He actually made a statement that we couldn't trust the judges.
Yeah.
At the time, the maximum was about 3-5 years or so. And he said we couldn't trust the judges. Yeah. And there was even opportunity of a fine.
Yeah.
So you see now the new law, as amended under your regime, is that it's not either or.
Yes.
You get both. You get the fine and you also get jail.
Get imprisonment.
President Akufo-Addo said some of the judges could not be trusted because they were taking money and giving them fines to run away. So this is how come you did this way. And then you increase the punishment.
You also even did not trust that we will get to that situation where you will send somebody to court for conviction. So instead we should shoot them on sight.
Be that as it may, the judge said something which we should pay attention. He said deterrence. And I'm saying that you cannot use Wontumi as a sacrificial lamb to arrest Galamsey in the realm.
They have not used.
So the deterrence that
apply the law.
No, the deterrence is as a deterrence. Therefore, I'll give this by 20 years. The people who are taking guns to shoot others, are they deterred by this?
So as I understand, part of your appeal will be on the sentence too.
Yes, indeed.
It's too harsh.
It's very harsh.
But the least you get is 15 years.
Yes, that is fine. But I'm saying that is what the law requires.
Some people are saying you were not in court. You should have been in court. If you were in court, maybe things would have changed.
I couldn't have improved upon the law if I were in court. Because, I mean, with the greatest respect, the judge was ready to give the decision. And the judge said, I mean, she will not defer the decision. And that my motion it's deemed read. And
same way, and American Yen ya wankrofo bi wo Ghana ha ya bobọ wo mu din se wo mu soso no etu galamsey ni bi ya min tie mi papa abanga a we third vice national chairman of NDC usu tie mi bi se wo ba Ashanti region so a ukọ adujama DC any MPO nana hima apamu na free na himfie se wo tu galamsey se uko Awowin constituency MP no won ye fe no Oscar Labi nana no matwa dwan ya gu ne so se wodan wirem onkofie en wo tu galamsey oti ase mo ya bobbo mo din nyina no mo hwe ade a atu Wontumi 20 years mo de how many years na mo betimi enya eti enne no ema wani nje because ye MPP ni a ye chema Wontumi ene ye de na tumu na me de tu e de na tumu no e wo tan eni bre oti ase ensem fata oti ase aho ya da bia NDC ehu wo mo no omo bade omo ba no se ehiafo na esikafo be pe ebe wi ase no na omo anya omo hu se tam da bia sa na de ye na me de me se nyame na nipa nyina destiny ana se ne bibia no ehye ne nsem nipa hyebre enhye nipa nsem nipa hyebre ehye onyame nsem eti mesre se ye nyina no ye nhwe dia akosue se dia akosue ne be magalamsey ejai dia ene ye nyina mbo na ye mbo abaso na se enne wate se sa dia we ato Wontumi na emma galamsey enyai dia ene minua ye ndwene hu ne ye ndwene hu mienu we na America asem we na America ne ntie ne yie ye wankofo